Ghanatube, so I was in format na CD and not just saying some abudu bi ekoso ewo omanga ni muitem pano ye bobo rem ni awakotie ensem na say ba na ne ka ho no media to aso e de amawo.
The High Court has adjourned proceedings to July 23 to hear the Attorney General's application to strike out the suspended Chief Justice's judicial review. Meanwhile, there's a latest from the Chief Justice. She has filed a fresh judicial review, this time against one of the petitioners seeking her removal. Stay with us. We're going to unpack the matters tonight on these key issues. And Dennis Wadam Esquire is with me. Now, some lawyers have expressed divergent views on the latest suit filed by the Chief Justice seeking a declaration that one of the petitioners' shining stars, you remember this is one of 3 petitions that we do know from shining stars seeking her removal, does not exist. He says this shining stars does not exist in law. A cross-section of the public also believe the Chief Justice is forum shopping. Now, the latest suit indicating that there are no records showing the existence of any such organization known as Shining Stars has gotten many tongues wagging. And to indeed get a bit more detail into this and to understand the context in which things are playing out. And I keep telling you that this matter of the petitions against the Chief Justice, Article 146 at play, and in all these processes seeking the removal of the Chief Justice, as she has been suspended now, proverbially, we say it's a rolling stone. It's gathering a lot of dust in many ways, as we're seeing. Yesterday, Dennis Wadam Esquire was in the studio. Dennis, we were caught talking about the Chief Justice going to the ECOWAS court.
Yes.
And then we're waiting for a date for that particular case. So we know whether the $10 million she's asking for and so on would be granted. And then now we wake up to this, a fresh move from her as well. But there was a case that was supposed to be heard today, correct?
Precisely so.
What happened to it?
Yes, and that's the more reason why we try to track all these cases, just so our viewers are able to follow every step of the way. Because you do recall that even before the Chief Justice went to the ECOWAS Community Court, on the 9th of June 2025, the Chief Justice filed what we called a judicial review at the High Court. And this was largely a matter that alleges violation of her fundamental human rights, for which reason she wants all the processes quashed.
Right.
Now, when that application was filed, the Attorney General also filed another application to set aside this June 9 application, or in other words, to set aside this action of the Chief Justice dated June 9. Now, today was supposed to be the hearing for that motion seeking to set aside the Chief Justice's application.
I see. And what happened to it?
So that could not come on because both the Attorney General and the Deputy Attorney General were not in court today. They were represented by the state attorney who explained to the court that they were out to attend to other equally important issues.
I see.
So they prayed for an adjournment for that one to be heard. That's just one leg of it. There was also the issue of non-service, because lawyers for the Chief Justice had also filed an affidavit in opposition to that particular application seeking to set aside the judicial review. And for that matter, they needed to have served same on the Attorney General and proof service of same.
Okay.
That proof of service was not available at the court at the moment. So the court also put that together, adjourned the hearing to July 23, and also asking that lawyers for the Chief Justice ensure that service is done upon the Attorney General and proof of same be shown. So for that reason, that hearing could not happen. But on the 23rd of July, other things being equal, the Attorney General will be expected to make a case to see as to whether or not the move to set aside this judicial review will be upheld by the court or otherwise.
I see. So this is the first judicial review.
Yes.
That the suspended Chief Justice.
In other words, that is the first action that the Chief Justice brought before the High Court.
Right.
Mind you, all other actions had been before the Supreme Court, which were largely constitutional matters seeking interpretation and subsequent injunction applications. The first time she came to the High Court was in respect of this judicial review. It's the same judicial review that she mentioned when she publicly addressed the nation on what's on happenings that were ongoing.
Yeah.
And that is the matter that is yet to be heard. Even before it is heard, the Attorney General says that, no, I want to set this aside. So the court should give the Attorney General the opportunity to be heard on that motion, which was supposed to be today. Like I explained, it's not been able to be heard. So we are hoping that on July 23, the Attorney General will make a case to see whether or not this application will be set aside.
It's an important distinction that you make, because then we are clear in our minds that there's a first judicial review,
yes,
which has not been heard. Now we're waking up this morning to another judicial review.
Precisely so.
By the Chief Justice?
Yes.
What is it all about? Let's get into that.
So that has to do with one of the petitioners seeking the Chief Justice's removal. And if you do recall, we have mentioned on this particular show that aside the human beings who have petitioned the President for the removal of Chief Justice, there was also an entity in there which also petitioned for the removal of the Chief Justice. That entity is called the Shining Stars of Ghana. Now, the Chief Justice is bringing this application to say that the High Court should make a declaration that this particular entity does not exist. Right. It does not exist in law, and it does not exist in fact. That is to say, you know, there are some entities that only exist in law.
True.
For example, a company, we say, has a legal personality. So in law, a company is deemed to exist as a person.
Right.
In fact, it would be like you and I, Alfred, people can see we exist. So the argument made here, or what is suggested here, is that whether it is in law or it is in fact, this entity does not exist.
It is like there's no traces of it
anywhere.
I see. Okay, so that's so for example.
Yes, so that's just by way of one of the reliefs that she's seeking by way of this particular judicial review. Right. Mind you, the earlier one largely had to do with allegations of violation of fundamental human rights.
Yes.
Now, beyond that, she's saying that one of the petitioners, one of my accusers, does not even exist in the first place. To start
Shining
with.
stars.
Shining stars of
She
Ghana.
hasn't seen any stars shining anywhere.
Not at all.
Okay.
She's also seeking another relief to the effect that the court makes a declaration that the petition to the President allegedly uttered by Shining Stars of Ghana is void. And why is she saying that it's void? That is void because of the fact that the Shining Stars of Ghana does not exist in fact or in law. It goes back to the same point of the non-existence of the entity that she's talking about. So if the entity does not exist, now following through that, she says that now this petition that has been sent to the President, purportedly uttered by this entity, is void because the entity itself, as she puts it, does not exist. The other relief is to the effect that the purported prima facie determination in respect of petition by Shining Stars of Ghana is null, is void, and of no effect. That is also mounted on the very first relief that has been sought, that this entity does not exist.
Right.
If the entity does not exist, how then does it petition? And based on its petition, a prima facie case has been made against her. So largely, those are the reliefs that she's seeking in that particular line. She's also seeking an order to bring up to this court for the purposes of caution, and accordingly caution the purported prima facie determination finding made by the President in consultation with the Council of State. That to the extent that based on a petition presented by an entity which does not exist was considered in a prima facie determination made, her prayer to the court by way of a relief is that such prima facie should be brought before the court for it to be quashed. And that's the essence of, the essence of the kind of application that she has brought before the court. Judicial review. Right. Usually you ask for orders in such nature. True. It's going to be a certiorari, it's going to be a mandamus, or in this respect we'll be talking about a certiorari. She continues. Well, so that's the final relief.
The reason that she together with her lawyers would have done their homework in checking the legal status of Shining Stars in every registration whatsoever. If it's an NGO, it's a company, a partnership, and they don't see any records of Shining Stars under any of our laws.
That is to be expected, especially so when you're making the argument that the entity exists in law. If it exists in law, there is a procedure or there's a standard by which an entity can exist in law. And that is one of the ways you find it either being registered as something or something else. But there's also the other question of whether it exists in fact. They make the argument that it does not even exist in fact as well.
I see. So it could be the case that an entity may not, just for the benefit of analysis, may not exist in law, but could find some remedy in fact.
Yes.
And some consideration could be given to an entity's claim, even if it is not existing in law, but there's some factual basis to the claim of the said entity that has no legal basis.
So that is why when you look at the reliefs very carefully, they are couched tightly to say that you see that it doesn't end with the construction doesn't end that does not exist. It goes on to specify in what form it does not exist.
Yes.
In law, it says it does not exist. In fact, it says it does not exist.
So that's on both fronts.
Yes. So it will be on them to show that yes, when it comes to the lawful existence of an entity, this is how it should exist. And we have done checks A, B, C, D. It does not exist. When it comes to the existence in facts, these are the things that we are looking at. We have done our checks A, B, C, D, and it does not exist.
Right.
When the court is persuaded by then, perhaps it will go on to make its orders and also grant the reliefs as the Chief Justice is seeking in this particular one. But mind you, there are quite a number of cases still pending. And for the purposes of our viewers, just to go back, as far back as May 21, 2025, she filed a writ of summons at the Supreme Court that is yet to be determined, more of a constitutional matter requiring interpretation. On the same day, there was an application for an injunction that was also filed on that day. That injunction has been determined and dismissed unanimously. On the 9th of June, a judicial review at the High Court. This matter is yet to be determined, but even before that, Attorney General has filed an application or a motion to set aside this one. This matter will be heard. The AG's matter will be heard on the 23rd of July. 4th July, a case had been filed at the ECOWAS courts. Before the substantive matter, yesterday a hearing was held, and that was for interim measures. Arguments were made. It was postponed for ruling on that particular interim measures.
Absolutely.
That date for the ruling, we still do not know. And now the latest coming in is the fact that there's a judicial review, and that is the Chief Justice seeking reliefs against the shining stars of Ghana, making allegations that it does not exist, either in fact or in law.
Dennis Poberi, Wadam Esquire, it's always great having you.
Thank you, Alfred.
Break down the issues. And let's stay the steam on this. And Martin Pebo is private legal practitioner. He's joining us on Zoom. Counsel, good evening. Thank you, as always, for staying patiently, hearing Dennis run through the reliefs that the suspended Chief Justice is asking for. We are very clear in our minds our limitations in discussing this topic this evening, so as not to be cited for sub judice. But looking at what Dennis has just put out, and the information that is publicly available, how does this latest move by the suspended Chief Justice strike you?
So, Mr. Kansi, as usual, we'll repeat the caveats, all right? This interview is not an assessment of the merits of the application filed by the Chief Justice. No, far from it. Rather, we are seeking to give education on some of the known issues, okay, based on past decisions and of the Supreme Court and legal principles. So we're just raising some of them hypothetically and answering. We are not discussing the merits of her application per se. I have not read the application. I've not cited it. It's the news item I've seen, so I cannot purport to be dealing with the substance of it. Okay, so that said, this is not the first time that a case has been raised against petitioners or a petitioner under Article 146. You know, even in the Kufuor's time, the removal of Charlotte Osei, there was the case that a certain petitioner was dead and yet was part of the petitioners. Can you imagine? The petitioner was reportedly dead, yet he was a petitioner. And the Charlotte Osei case went on, and then we all know what happened to Charlotte Osei. Okay, yeah. That apart, now let's come to a decided case the Supreme Court has dealt with in respect of Article 146. So there is a case of Justice Logo, Justice Derry, and then others, and Justice Eyisi also, against Tiger IPI, the Chief Justice, and then the Attorney General. Now that's a case that happened in 2015. So for lawyers and also for those who are interested in reading the full report, when you want to read, it's cited as 2015, 2016, one Supreme Court of Ghana law reports, right? Yes, 2015, 2016, sorry, volume 2 Supreme Court of Ghana law reports. Okay, so in that case, the Justice Logo, Justice Derry and co raised an argument that Tiger PI is not registered as a company. And you know, a law, if you register a sole proprietorship at the Registrar General, that is not a limited liability company. So in simple terms, a sole proprietorship, or when you hear business enterprise cannot sue in its own name. It doesn't have separate legal personality. To get separate legal personality, you have to incorporate a company. The one you hear, limited liability company, or even we have unlimited companies, and also we have the NGOs, right? Yes, guarantee companies, etc. But the one called sole proprietorship or enterprise, it doesn't have a separate legal personality. So it's the case that though Anas wrote the petition, and even when you read the report, it says that the beginning line, Anas says that Anas, as a citizen of Ghana, brings this petition. I'm paraphrasing. Maybe if there's time, I can refer to it and see what the Supreme Court said. So they looked at the beginning paragraph and then decided that, the petition was brought by Anas in his personal capacity, notwithstanding the fact that he used the letterhead of Tiger IPI. Tiger IPI. So based upon it, the Supreme Court said, look, we are looking at substance over form. Substance over form. That's a principle we've used on this program, Ghana Tonight, the key points, etc. It's a principle that is known to law, known to accounting, known to many other professions. Substance over form. So the Supreme Court said, yes, the petition was done on Tiger PI letterhead. Tiger PI is not a limited liability company. Yes, we agree. But the person who wrote the letter says I. So let me read. It says, this is what the Supreme Court at page 1061 of the report said. The substantive part says, this is the humble petition of Anas Aremiyao Anas and Article 146, etc. So the Supreme Court said, look, you see, the person says, this is my petition, but he put it on the letterhead of a sole proprietorship or this enterprise. That cannot make it the work of the enterprise, but it's the person who signed. He signed in his personal capacity. And by the way, yes, this is not the first time, even in court, when you sue in the name of an enterprise, then sometimes a mistake is detected. Yes, they do the needful and then they're able to save the case because the enterprise is the person himself. Lawyers know the case of Isufu versus this Isufu Kabori versus Ghana Ports and Harbors. Yes, the Supreme Court looked at it. That's in the early 90s, I think 93, 94 Supreme Court, thereabout. Supreme Court said, no. Look, these kind of things, we'll just put the man's name there. The court is there to do justice. There are a number of other cases I can refer to. So what we should be taking away from this whole interview is that the Supreme Court says they look at the real issues. They are not there to be deflected by fanciful possibilities. No. So if only they find an identifiable name and then it is signed, so they can identify that this individual, this is his name, he signed it, the court may well save it. Yes. Okay. So that's one case that can illuminate this process. that at least the Supreme Court looked at it and said, look, they are doing substance over form. They want to get to the real issues. Maybe there's a bit of time. Let me see we can read just the last paragraph of the Supreme Court decision saying that they will do, yes. It says, the submission by the plaintiffs that the first defendant, Tiger IPI, is an unincorporated body and therefore incompetent to submit a petition to the president is not only disingenuous, it is a ruse to sway this court from the real issue. You see, it is a ruse to sway this court from the real issue. We find the submission unwarranted and would dismiss same. Okay, so that's what the Supreme Court did in the Justice Logo, Justice Derry, and Aissie Ado versus Tiger Eye. Okay, so I mean there are other parts of the decision that we cannot go into, but because of lack of time. So right. These are the principles, and as I mentioned, the key thing is that the Supreme Court in other cases have said that they are there to do substantial justice. Of course, we should know that there are limits too.
Right.
Yes, if the person is totally dead, generally, a dead person cannot start a petition. But even then, of course, I'm not citing it as a good example, but I'm saying that even then, in the Charlotte Osei case, it was reported that one of the petitioners was dead. But presumably, because the other petitioners were alive, the petition went through.
True.
So we're just expanding the principles. Who knows? As Justice Torkornoo is challenging these things left, right, center, by the time she's done, they would have generated a lot of decisions that would also help. So in doing this, she's advancing our democracy. She's also expanding the frontiers of our legal jurisprudence, because this will result in a court decision. And it will illuminate the process. So for me, as I've always said, it appears it's better.
Yeah, but Council, there's a point I just wanted to have you quickly respond to, just for the benefit of clarity. If you're there, and then maybe if we just reposition, because there's a break in the connection. Is that to say that the legal status of a petitioner, not with direct reference to this case, but the legal status of a petitioner in a case cannot invalidate the details of the said petition?
No, we can't use one decision, one Supreme Court decision specifically on 146 to conclude, right? You can never make that argument. That is not material. It all depends on the circumstances of each case. Except that the court is saying that when they see a real issue, so if what is in the petition is weighty, and then an identified person has signed it, why would we go and say that, oh, because maybe at one point the petition is made to look like it is a company, then in another point it's made to look like it's an individual, so we throw it out? No. That's what the Supreme Court has said in this decision. But remember that one Supreme Court decision specifically on the capacity of a person to present a petition under Article 146 is not sufficient to conclude, no. Until when the Supreme Court thinks they've given a number of decisions and so they think that is all, they will state it. When it comes to Article 181, yes, the international laws, etc. Yes, after the Woyome, Isophoton, those cases, the Supreme Court finally said, look, we think we've explained this area of the law enough. If anybody has any challenge against these provisions, the person should go to the High Court. Okay, but for this side, we cannot say that's under Article 146. We can't say that the Supreme Court has exhausted all the jurisprudence, every opinion it wants to render. Not yet. Okay, but you remember, so because this only one decision under Article 146 specifically, you see, I brought in other cases from court. I mentioned Isufu Kabore versus Ghana Ports and Harbors. There are other decisions, you find Amprechu versus divestiture implementation, the whole lot. So the main things that the Supreme Court had announced, I mean, that's 2007, 2008, that they've moved away from technical justice to substantial justice, substantive justice. Yeah, they are not doing technicalities, just technical justice, but they want substantive justice. So they want the justice to be functional. They want the justice, you know, like we say, the law was made for man, not man for the law, those kind of things. And just like what the Supreme Court said in the Justice Logo, Derry and Isiado versus Tiger Eye, that they are looking at substance.
Over form, essentially, the substance over form, as you've earlier referenced. Thank you. Martin Pebo is private legal practitioner, and this is a matter that has just come up today. The coming days as well would offer us a lot more time and some references to bring matters in perspective. But
I was here for me now, as I said, we did mechi equity in some koso ewo Ghana we dear me the movie see and so many major comments no Emma me comment section that would drink ewan sending now no for comments in the Ebra and magic bread I can kind Ama fe me kai will be search channel way Ghanatube. So don't forget to subscribe, hit on the notification bell, share and like all our videos. I was here for Snowy Day. Sisi Ade, Makramo.